Good morning. This is a short video clip for the Level 3 BTEC students, Group 2B, and it should help you prepare for the presentation for Assignment 2, past Task 3 and 4. I'm just going to go through the key legal things that you need to think about during your presentation. We've already covered this particular topic, but this video clip serves as a short reminder. Right. So the first thing you need to remember is that you can divide your presentation into 3 separate parts. And the key idea of dividing your presentation into 3 separate parts is to help you deal with the different aspects of laws in relation to the status of the worker, but more importantly, the implied duties of the employer and the employee. So in part 1, the first thing you need to talk about is why it's important to establish the status of a worker. An example we gave is that the City Council may employ 2 drivers, for example. One of the drivers will be classed as employed and the other self-employed. It's a very important concept that the main employer who employs 2 separate individuals with separate statuses would have to know what their responsibility is to those 2 individuals. Right, so the 2 main types of workers we have generally in most employment environments would be somebody who's self-employed, also known as an independent contractor, or somebody who's employed, known simply as an employee. The other key principle is sometimes when you have a look at contracts of employment, the 2 types of workers, self-employed or independent contractor or an employee, would be described differently. There are certain terms which help you identify whether you're dealing with somebody who's employed or somebody who is self-employed. If somebody works under a contract of service, it simply means that they're classed as an employee. The general idea behind somebody working as an employee is the fact that they have a lot of legal protection. If another person works under a contract for services, the idea is that they are self-employed. The advantage of being self-employed is if your business is profitable, then you keep all the profits. There's also the risk that if things don't go well, then you're solely responsible for any financial difficulties. So a contract of service relates to an employee, a contract for service relates to somebody who's self-employed. Now, the next thing we need to have a look at is the rights of somebody who's employed. And it goes without saying that if you're employed, there are various pieces of legislation that protect you. The most basic one would be the Equality Act 2010, which simply prevents you from being discriminated against based on the 9 protected characteristics, but also based on equal pay and so on. If you're self-employed, you don't have as much protection. So in your presentation, it will be very important to get across the difference and the different rights that different types of workers have. Self-employed, essentially you're on your own. If you're an employee, the idea is that you're fully protected. Equality Act 2010, also the Health and Safety at Work Act 1974 gives you that protection that wherever you work, your employer must ensure that they provide you with a safe working environment. Right, so that deals with everything for part 1. We've now moved on to part 2, and the idea of part 2, or the content of part 2, is identifying the different tests used to find out whether someone's employed or not. So we're looking at the different tests that the courts use to identify the status of the worker. Right, so the first thing we need to talk about is the first test, which is the control test. And from previous discussion, we've gone through this already. The control test is simply about whether you as a worker or an employee are controlled by your employer. If you're told when to arrive at work, when to have your break, what uniform to wear, what tasks to complete and so on, then the general idea is that you're under the control of your employer. And therefore you're not self-employed. Based on the control test, you'd be classed as an employee. And in your presentation, that has to come across very clearly. Now, these tests are based on how things used to be. So the first one is an older test because it was based on the employment relationship of master and servant. That so much doesn't occur today because most of the time we're encouraged to work on our own initiative. Now the second test is the organisation test, and you don't have to prove all three. In most occasions only one might apply. So the organisation test is simply looking at whether an individual works within a particular organisation. It simply means that anything they do wrong tends to be the responsibility of their employer. So just being part of an organisation tends to suggest most of the time that you're not self-employed, you are rather an employee. And the final test is referred to as the multiple or economic reality test, and that's all about the course looking at how you work. Are you told what to do? Do you have responsibility of ownership of what you do in the workplace? Is your employer obliged to give you work, and are you obliged to take that work once it's given to you? So the multiple test or the economic reality test is all about looking at how somebody works and then working out whether they look more like an independent contractor or a self-employed person. Don't forget, when you talk about the three different tests, you would have to support your answer with cases or legal authority. So Motorola and Davidson relates to the control test, and so does Dacas and Brook Street. The third case here, Cassidy and Minister of Health, relates to the organisation test. And the economic reality test is the case that relates to that would be Ready Mix Concrete and Minister of Pensions, and all these cases will be in the slides that I went through, which will be available on Interact. Right, so that deals with part 2. In part 3, you're mainly looking at the responsibilities of the employer and the responsibilities of the employee, and then it's just a matter of talking about the expectation that under a contract of employment, the employer has to do what they have to do, the employee has to do what they're required to do as well. So, the important thing to start, the important content in part 3 will be to consider the difference between an express term and an implied term. An express term, as I mentioned before, is simply the things that you can physically see in your contract. Anything written in your contract tends to be an express term, so it will clearly identify the contracting parties. This contract is between a particular organisation and an individual. It will talk about when the contract of employment started, what your remuneration will be, what your holiday entitlements will be, and so on and so forth. So all the terms you see in the contract are classed as express terms. However, in addition to express terms, we have implied terms. Implied terms seem to be invisible, they're not written anywhere in the contract, but they make sense that they must be a part of the contract, and without them, the contract doesn't seem to work properly. Now, the different ways in which an implied term is added into a contract are mainly by the common law, so certain cases, such as Donahue and Stevenson, it's a tortious case, a case based in the law of tort, but the idea is that if you're working close to your co-worker, then you have to be careful how you carry out your work. You don't want to do anything that would endanger their lives or even hurt them. So that's based on the common law adding an implied term of duty of care. Be careful when you're working next to another person. So that's the first method of incorporating an implied term into a contract of employment. The second method is by an Act of Parliament. So again, another one closer to health and safety would be the Health and Safety at Work Act 1974. It imposes a duty on the employer to provide you with a safe working environment. So the answer to this particular point is there are two main methods in which implied terms are added into a contract of employment. The first one is by the common law, and the second one is by an Act of Parliament. Right, implied terms, what we're looking at here is what duties does your employer owe you? And the first one we spoke about was a duty to pay wages. Your employer has to pay wages. It doesn't necessarily mean they have to provide you with work, but they certainly have to provide you with wages. There are times when they do have to pay wages, but also provide you with work. And we spoke about individuals or workers who are skilled workers. If you're a doctor, you're a footballer, you're an actor, actress, then it's imperative that you're given work constantly in order for you not to lose your skill and ability. So the first implied term of an employer is to pay wages. The second one is to provide you with a safe working environment. And that is generally common sense. The third duty we might have spoken about was a duty to indemnify you. So again, if you make a mistake in the course of your work, so for example you're asked to drive a car to pick up an item from another business and you accidentally knock somebody over, then it's your employer's implied duty to indemnify you, which simply means lift the responsibility away from you and place it on themselves, and they have to deal with it. We did say in the lesson that this would also mean that you might be dealt with internally. If there are internal procedures that deal with you being negligent whilst you're carrying out your duties, then you could be in trouble based on that policy. The other duty that your employer owes you will be a duty of good faith, and that simply means that they have to trust you. They gave you the job in the first place, so if you feel in any way that you're not being trusted, then it could mean that your employer is breaking their duty of good trust. In the case of Murrow and Safeway, where an individual worker was disciplined and embarrassed in front of customers, indicates that the employer did breach their duty of good faith. And the duty of good faith also involves a duty that they must trust and respect you. So those are the implied duties of the employer: to pay you wages, to provide you with a safe working environment, to indemnify you, but also a duty of good faith. The employee's implied duties are very similar in a way, but I think the most obvious one would be a duty to obey reasonable orders. The case of Pepper and Webb, which we've dealt with before in P5 as well. So if you're asked to do a reasonable and lawful order, if you refuse, then you could be breaking your contract of employment, to which your employer may decide to dismiss you without notice. The second implied duty of the employee is to make sure they carry out their duty with care and skill. And the case of Lister and Romford Ice is a good case to think about, which places responsibility on the employee to make sure they don't injure anybody whilst they're carrying out their duties. Another duty imposed on the employee is a duty of good faith, and generally that simply means that you have to be honest and fully committed to your employer. There are certain types of employment which doesn't allow you to divulge trade secrets and so on and so forth. You may not even be allowed to work for a rival company, and therefore as soon as you sign your contract of employment there might be a clause that restrains your opportunity or your chances to move to another business within a particular radius of where you currently work for a period of time, called a contract in restraint of trade clause. So they're the main duties of the employee, the worker. They have to obey reasonable orders, they have to be careful how they carry out their job, they owe a duty of good faith, and also they have to account for profits. If somebody gives you a gift in the course of your business, then generally speaking you do have to declare that. So these are all examples of the implied duties of the employee. And then the last point is to just draw your basic conclusion. I think the idea of drawing conclusions on this presentation is to state how important it is to identify the difference between who an employer might be taking on into an organisation. Are they self-employed, working under a contract for services? Are they an employee working under a contract of services? The presentation should last 10 minutes. I'll be asking you questions after that. I think that's what this point says. Thank you very much for watching the video clip, and I hope it's useful for you in preparing for the presentation, which I shall sort out a schedule very soon. Thank you.